So let's presume there is an ongoing workplace investigation, whether or not the individual has been suspended. Then the issue becomes, well, what should be the grounds of fairness in the investigative procedure? And the courts have developed certain principles that should be followed. First of all, the person who is the subject of the investigation, if I call him or her the suspected one, should know the substance of the allegations that are being made against them. Fundamental. And also, they should be given the right to respond. The investigation preferably should be done by a neutral third party, preferably external to the employment relationship, and should be fair and thorough. If there is a policy manual, many companies now do have policy manuals outlining what steps should be taken and how the investigation should proceed. If there is a policy manual in existence, the suspected one should be given a copy of the policy manual, and also, obviously, the policy manual should be followed. Once the individual is aware of the nature of the allegations made against them, then they should be given a fair and reasonable time to prepare for the interview and be given a full opportunity to reply to it. Also, any relevant documents should be given to the individual. It's debatable whether the individual should be given the right to receive legal counsel. My view is that the person should, but the law is not clear on this. But certainly, if you're looking from the point of view of the employer and you want to ensure everything's fair, why not? Why not give the person the right to retain counsel and get advice? That doesn't mean legal counsel will be entitled to attend the investigative interview. It's a different issue. But certainly the person should know through legal counsel what their rights are in the process. All original notes of the investigator should be retained. There may be taped video interviews. One case has said that's a very good idea. And if the interview is videotaped, obviously, I'm just cheating. The interview should be the tape should be kept. The inquiry made to the individual should be limited to the nature of the allegations made against that person. The investigation should be one of strict fact-finding, and the investigator should ask neutral questions without having a hidden agenda in the question, as the answer should not be in the question. That is, you are really trying to do nasty things to Susie, weren't you? As opposed to the question should be, tell me about your relationship with Susan and tell me what happened on whatever date it was. Fair summaries of the evidence should be kept, and also given to those persons adverse in interest. One case involving a federal statute said that once the investigator had determined the evidence of the other persons involved in the process, the investigator should have doubled back to the suspected person and said, hey, listen, this is what Mark, Rob, and Sue had said. What do you say about this? And that was a reason for setting aside the decision. Now, that was under a federal statute, which may be a different standard, but nonetheless, likely it's a symptom of fairness that should be followed. And again, the investigation should show all hallmarks of being fair and unbiased. Very often in workplace situations, the witnesses talk to one another in advance, even before the complaint is made. So Susan tells Mary, this is what happened last week, and Mary says, you know, he did something like that to me as well. And then there are 3 or 4 of them get together and they all discuss the situation collaboratively, which should not be allowed. And that may go against the credibility of the people that are testifying or giving evidence in the investigative process. Ideally, each person's evidence should not be influenced by hearing what other people have said. And in that manner, the investigation may be determined to be fair. If those rules are violated, then we got a big problem against the employer. Now, even all that being said, the courts have also allowed the employer to present a case of just cause, even if the investigation has been unfair. So the employer can still argue, hey, we did have cause to terminate him. Our investigation may have run afoul of the expected standards. But look, Judge, this is the evidence that we do have to justify the termination. And the court may well consider that and still find just cause for termination. Where it doesn't find just cause for termination and the investigation has been unfair, then watch out, because there's going to be awards of aggravated and punitive damages, very likely.